Welcome back to our last session of the day. I'm Martin Schmalz, Chief Economist and Director of the Office of Economics and Risk Analysis. I'm joined by Barbara Vanit, Chief Auditor and Director of Professional Standards. Barb and I are joined by Karthik Ramana. Karthik is a professor of Business and Public Policy at the University of Oxford's Blavatnik School of Government, who has taken a partial public service leave to advise the PCAOB. We would like to welcome our panelists, board members, and the public back to this staff-hosted roundtable on the auditor's responsibility for a company's non-compliance with laws and regulations. Before we get started, I want to issue the standard disclaimer for myself, Barb, and Karthik one last time for the day. Our views are our own and do not necessarily reflect the views of the board, individual board members, or staff. We would also like to remind those listening that the comment period will be open until March 18th, 2024. We welcome all comments. The staff are particularly interested in substantive comments from the public concerning the roundtable topics and any points raised during the roundtable. On June 6, 2023, the Public Company Accounting Oversight Board proposed amendments to PCAOB auditing standards related to a company's non-compliance with laws and regulations and other related amendments. The PCAOB received 140 comment letters on the proposal. From those comment letters, the staff have identified several topics for which we believe additional information will be helpful in developing our recommendation for the board. The purpose of today's roundtable is for staff to obtain the perspectives of our panelists on specific aspects of the NOCLAR proposal that the board issued in June of last year. Additional background information on the topics and questions we are covering during today's roundtable is available in the staff briefing document available on the event page that you will find linked to the homepage of the PCAOB website. Barb, Karthik, and I are here to listen. We will direct specific questions to our panelists in order to inform our efforts as we work toward a final recommendation to the board. Our objective is to hear from all panelists who wish to speak on each topic and to encourage open dialogue among the panelists within the time allotted. We have 2 hours. As a reminder, if you would like to say something, please just use the raise your hand function. If that's not working, just type something in the chat function. No need to write down your question. Just say, call on me, or a few characters, whatever works, and we'll do our best to get to everyone. In the event that we run out of time, we welcome all panelists to submit additional comments to the comment file. If you have any technical difficulties during the meeting, please contact Brian Goodnow. Thank you in advance for your patience. A note to those watching online, panelists were asked to submit any new data or analysis they plan to present here today to the comment file ahead of today's meeting. To ensure all panelists have time to speak, we will not be able to accommodate slide presentations from individual panelists, but we encourage the panelists to reference any such submissions to the comment file. Those watching online can find those submissions easily by going to the PCAOB website, clicking on the event page that appears on the homepage, and then selecting the comment file option on the right-hand side of the screen. The comments are ordered by date helpfully. The most recent submissions, therefore, are at the bottom of the page. With that, let's get started for our last panel of the day on economic impacts of the proposed standard. We have 10 distinguished panelists with us. There's Brian Crotto, who's a US Chief Auditor and Auditing Services Leader of PwC, Colleen Honigsberg, Professor of Law, Stanford Law School, Jonathan Karpov, who is the Washington Mutual Endowed Chair in Innovation and Professor of Finance at the University of Washington, Dennis McGowan, who's a Vice President, Professional Practice at the Center for Audit Quality. We have Carol McNeese, who's a CPA and Director of Quality Management, Ethics and Assurance Policy at Plant Moran. There's Laura Posner, who's a partner at Cohen Milstein, Tom Quadman, who is Executive Vice President at the U.S. Chamber of Commerce Center for Capital Market Competitiveness, the Chamber Technology Engagement Center, and the Global Innovation Policy Center. We're glad to have Brandon Reese, who is Deputy Director of Corporations and Capital Markets at AFL-CIO, as well as Bob Temple, who is General Counsel and Secretary at NewScale Power Corporation. And finally, Luigi Zingales, Distinguished Service Professor of Finance at the University of Chicago. You can find bios for each panelist on the PCAOB website. We have one topic for this panel, which is the benefits and costs of the proposal. By way of introduction to the topic, the expected benefits of the proposal include improving financial reporting quality by requiring auditors to better identify, evaluate, and communicate a company's non-compliance with laws and regulations, which can lead to more timely intervention by companies to seize and remedy non-compliance, thereby reducing the harm to investors and the public at large caused by non-compliance. To the extent that investors currently expect that auditors play a larger role in identifying non-compliance than they actually do, as some commenters have indicated, the proposal would help reduce the expectations gap between investors and auditors, which can increase investor confidence in financial statements and the capital markets generally. The proposal identified costs of the proposed standard to firms that would include certain fixed costs related to updating audit methodologies and tools and training staff. Variable costs for firms would include efforts to identify the relevant laws and regulations, assess the risks of material misstatement due to non-compliance, and develop audit responses. The magnitude of the costs will likely depend on the nature of the company and its operations and the related regulatory environment. The proposal also highlighted that the likely cost of the proposed standard to companies would include engaging with the auditor to respond to information requests and increased audit fees. I want to briefly tee up all the questions that we want to ask. We have 6 questions. We will try to go in order, but just in case, we will have panelists respond to costs and benefits jointly. I want to just tee up all of them at the beginning. Our first question is, what do panelists or commenters perceive as the economic benefits and costs of the proposals, and how do they differ from the status quo, both quantitatively and qualitatively? We discussed earlier today what the status quo is and what additional work is required, and we're interested in finding out what that quantitatively means. I'll add to that, I'm particularly interested also in the methodology, if you can explain that you would have used to assess these costs and any justification of that methodology. So whenever possible, we would also be interested in hearing responses separately by firm size. So perhaps they differ by large or medium or small firms, as well as perhaps different responses to different stakeholders, for example, preparers versus firms. That is the first question. The second question regards any additional data or studies that would clarify the economic impacts of the standard. So if you're aware of additional data or studies on the current cost of unidentified non-compliance with laws and regulations to investors or the public at large, we would be interested in hearing about that. The third question is whether what the panelists or commenters perceive as the impact of the proposal on small and medium-sized audit firms, and whether such an impact can be quantified differently. The fourth question is what broader impacts you may have identified of auditors' identification of non-compliance with laws and regulations that could reasonably have a material effect on the financial statements. So that's question 4, Brian. So that could have a material effect on the financial statements, on capital formation, or more broadly, the macro socioeconomic environment. I'll add to that the environment, the proverbial chemical in the river. Are there any data or studies that would help us estimate those impacts? For instance, is there evidence to suggest that capital costs would be lower if investors had greater confidence that auditors would identify non-compliance with laws and regulations that could reasonably have a material effect on the financial statements? The fifth question is, to the extent panelists and commenters provide additional alternatives to the proposed standard, if there's any data or studies that can help us estimate the benefits and costs of any of these alternatives. And finally, the last question we want to address will be, in light of the discussion of costs and benefits, we will witness how investors, issuers, and auditors view the justification of the proposal overall. So in discussing these costs and benefits, we strongly encourage the panelists to be prepared to discuss the quantitative impact of the proposal on audit fees, on issuers' internal costs as a result of identification, evaluation, and communication of information indicating that non-compliance with laws and regulations has or may have occurred, auditors' existing reliance on compliance work and legal analyses already carried out by issuers, and potential costs associated with the auditor's use of specialists. Now, let's go back to question one, now that we've teed up the entire spectrum of what we intend to discuss in the next hour and 45 or so. The first question again is what the economic benefits and costs of the proposal are relative to the status quo, both quantitatively and qualitatively, ideally split up by different sizes. So I saw that on Monday, Professor Honigsberg submitted an additional comment letter that speaks to both costs and benefits. So let's start with that.
So thank you guys for having me here today. And yeah, when I was thinking about the broader sort of cost and benefits, I actually went through the comment letters. And so I went through the comment letters to just get a sense of what are, both potential direct and indirect costs. Also, what are the broader potential unintended consequences, which I think would be, more severe here than perhaps the direct and indirect costs. And then separately on the benefit side, what are some of those benefits that we would want to consider that are potential or direct, indirect, unintended, however they may come out. So I can kind of go through and just describe what are we thinking for the direct costs and indirect costs. Well, obviously, we have direct fees of terms of, auditors, lawyers, IT, software, higher potential litigation exposure. A number of people noted, and I assume we'll discuss that in more detail from some of my colleagues on the panel. In terms of the unintended consequences, though, I think these are just, in my view, cannot be quantified, and so I'm happy to discuss them. But it's like they're, sort of broader comments about, maybe we have fewer public companies, or maybe we have more consolidation in the audit industry that may or may not occur, and that I think I personally would not be comfortable quantifying because it would require too many assumptions. So I'm happy to actually go through and read out the unintended consequences, Martin, if you think that would be helpful. But yes, is that?
Sure, go ahead.
Okay. So the first one, greater demand for those with specialized expertise, making it difficult and expensive to recruit and retain qualified personnel. That one seems fairly direct. We also have potential reduction in audit quality because you have auditors who are being squeezed on fees. That one, though, of course, that's a potential benefit too. So I don't think we know exactly which way that's going to go. So risk of violating PCAOB and SEC auditor independence rules. This one, I believe, came up this morning. And, there was certainly pushback on whether that would occur. So increased time to perform an audit because it would be more work and perhaps more demand for particular specialists. Reduction in number of public companies, potentially weakened attorney-client privilege, again, something that was discussed this morning and that I think there was a fair amount of pushback on. Increased risk of market concentration for the audit firms, increased information overload for the audit committees because there would just be more information communicated to them. Perhaps real effects on business operations like inability to justify continued operations in certain areas. Greater tension between auditor and management, and then increased stickiness between the audit firm and the issuer, because we would have an audit firm that would have to bring in somebody new would be greater fixed costs, greater upfront costs right away. Now, on the potential benefits of NOCLAR, though, I think you've already hit on a number of them, but I think our main one would be, reduced frequency of detected and undetected fraud, which I am guessing my colleagues here on the panel are going to discuss, but is, when we're thinking about the effect of fraud on market cap is huge. And so I assume we'll get into that a little bit more. Certainly we can try to cost out what the effect of fraud on market cap would be. And I'm guessing some of my colleagues might, have some insight there. But obviously that one's really, really difficult to quantify. So certainly a huge cost, but very difficult to quantify. Also potential reduction in information asymmetries between investors and the audit committee or the managers, and then also the auditor and audit committee. Improved compliance environment within the firm, so allowing for better decision making, improved audit quality, and better alignment of investor expectations and auditor behavior. So again, we have a lot of potential costs and benefits that I think, in my view, in the comment that I submitted, I think we can try to anchor some of those numbers, but can I come to a number that I feel like I can really quantify the cost of the proposal? No. Do I feel like I can really quantify the benefits of the proposal? No.
Thank you very much, Professor Honigsberg. May I call on Mr. Quadman next, whose comment letters have quantified the cost of the proposal.
Sure, Martin, thank you very much, and appreciate the board having this roundtable today. Let me just give a few thoughts, answer the question, just a couple other general thoughts as well. So first off, in writing for unanimous court in TSC versus Northway, Justice Thurgood Marshall rejected a theory of materiality that would require disclosure of a fact that might be important to an investor. Instead, Justice Marshall held that a fact is material if there's a substantial likelihood that a reasonable investor would consider the importance of a fact viewed within the total mix of information to an investor in deciding how to vote. In a later case, Basic versus Levinson, the Supreme Court reiterated that TSC materiality standard and extended it, in fact, to investment decisions. Those Supreme Court decisions are important as financial statements provide material information for investors. Auditors provide the assurance that those statements can be relied upon. The almost 50-year standard on illegal acts with its direct, indirect test regarding financial statement impacts works seamlessly within that TSC rubric. The Chamber has long called for updating auditing and accounting standards. Indeed, we have written to past SEC, FASB, and PCAOB chairs with proposals on financial reporting reforms. However, any updates and reforms must be evidence-based and follow appropriate legal procedures for due process and transparency. NOCLAR process here falls short on all those points, and we again call for its withdrawal. Furthermore, under the Sarbanes-Oxley Act, PCAOB standards must be submitted for approval and directs the SEC to follow the process under Section 19B of the Securities Exchange Act. If the SEC were to attempt to approve the NOCLAR standard, it would violate the various holdings of courts, various courts, from our challenge of the mutual fund rules in 2005 all the way towards successful challenge of the stock buyback rule last year. In coming days, we're going to file a comment letter as well as a study outlining in detail the process flaws and cost-benefit deficiencies that the NOCLAR proposal suffers from. Let me just name a few. First, the board has failed to share a rationale for changing well-settled policy that has worked in the past or provided any evidence for the need of a change. The board also has failed to consider reasonable alternatives. Second, the board has failed to provide any cost-benefit analysis to NOCLAR for commenters to comment on. To be clear, benefits cannot be understood unless relevant consequences are considered and costs are qualified. Simply stating that a proposal will benefit investors doesn't make it so. Using data from Audit Analytics, the Chamber in its comment letter estimated that NOCLAR will drive up audit costs by at least $36.4 billion. Public companies and their investors will have to bear those costs and diminished return. This will accelerate the decline of public companies, and in fact, I'll submit it. This is a University of Chicago chart showing the number of public companies in the United States since 1996. That is a downward trend. That will increase. It will also endanger the global leadership of the United States in public capital markets. On its face, NOCLAR fails to meet the SEC's legal mandate of competition and capital formation. The board also failed to take into account increased litigation risks for public companies and audit firms, The board failed to consider the legal expertise and subject matter experts that would have to be hired by audit firms. The board does not consider how auditors would have to deal with conflicts of law issues. This is interesting since the first congressionally mandated resource extraction rule was thrown out by the courts on exactly that point. The NOCLAR proposal seeks to replace the objective indirect test with a subjective standard. So, for example, the board uses the term reasonableness without definition. NOCLAR uses the term reasonableness in the manner that the Supreme Court rejected in the use of might in TSC. Furthermore, as stated in our 2015 letter to the SEC and PCAOB on internal control reforms, I just want to cite what SEC management guidance states. The concept of reasonableness of necessity contemplates the weighing.
Mr. Portman, I wonder if I can direct you to the question on costs and benefits.
Please let me, Martin, please let me finish because there's a number of different issues I want to make sure I cover, and I'll be finished in a second. The concept of reasonableness of necessity contemplates the weighing of a number of relevant factors, including the cost of compliance, which you have not provided anything on. So that is troubling. I can get into some other things later on, but I would have to say, based on the data, I would also have to say, based on the change in capital formation, the capital formation markets with interest rate increases as well as deficits, it is much harder to raise capital, and that has not been taken into consideration by the board as well. Lastly, I would just say the board also fails to take into account how FASB moved away from its loss contingency proposal years ago because of the same issues that were raised regarding attorney-client privilege and litigation risks. So just want to put that out there.
Okay, thank you. So I didn't hear anything on a substantiation of the cost estimate or on benefits here. I wonder if Mr. Temple might speak to that. Can I call on Mr. Temple on that?
With all due respect, you have to provide that and we have to react to that. There are court cases holding that. And if we're not going to do it here, we're going to do it in the SEC rulemaking process.
So may I please call on Mr. Temple if he would like to speak to the cost estimate?
Well, and I guess, to Tom's point, the PCAOB bears the responsibility to project the likely cost of compliance with its proposal, not only to inform the public, but our comments as well. My company is an issuer, which is a small emerging growth company for which full SOX 404B compliance is still in our future, but near future. Simply stated, expanded auditor scope and requirements impose a cost to my business that I can ill afford. As a public company, we already receive appropriate auditor inquiries about compliance with laws to management and to directors under the current auditing standards. Compelling auditors to become specialists in business lines and having them perform compliance reviews would impose additional costs, but I cannot be certain as to what those are, Martin. I just have not studied it enough to tell you. We spend well over $1 million on our audits last year. And I expect, certainly with SOX 404B testing, starting in 2024 for us, our audit expense will increase based on that alone. Having additional requirements, having a broader inquiry, having new specialists required that understand our business and have legal competence, they have to impose additional costs. I just don't know what those are. Oops, Martin, you're still muted.
I think you might need to unmute Martin.
Excellent. Thank you very much for the bailout. Thank you very much, Mr. Temple. I wonder if Professor Zingales could speak to costs and benefits.
Yes. First of all, thank you very much for inviting me. Can you hear me?
Yes.
I think that non-compliance with law regulation can be extremely expensive for investors. And I think that the cost can be mostly of three nature. One is firms get caught and pay large fines and sometimes even punishing damages. So I think that those are important costs. Second, even if they're not caught, to the extent that the market perceives that there is a non-compliance and so there's something going wrong, there might be an important lemon discount, at least this is the term we use in economics, there's some form of reluctance to deal with a firm from the point of view of all the stakeholders, whether these are investors, these are customers, or these are employees. And of course, there are important externalities. So if I am an oil company that bribes an African government, I create an enormous amount of instability in the African country as a result of the corruption. And that's something very, very hard to measure, but can be really first order. Now, with two co-authors, I try to measure the first two of these costs. And we have some innovative methods to try to calculate how many of these non-compliance go unnoticed, because very often the research focuses only on the one that we do notice, that tend to be the visible part of the iceberg and not the all. And while we limit our analysis to large firms, more than 750 million in sales, I think that we find that roughly 10% of these firms are non-compliant in a way that is sufficiently material to generate a non-trivial lawsuit. So these are not small non-compliance, but large non-compliance, and they are quite pervasive among large firms. And on average, these non-compliance tend to destroy 16% of the value of equity. And so on average, basically, the non-compliance of publicly traded firms destroy 1.6% of market capitalization per year, that the current value is $800 billion per year. So these numbers are very, very large. Now, you're saying, why do we care about this number? Is because the aim of this regulation is to reduce this number. Now, how much this regulation will be able to reduce this number, I think it's very hard to estimate on an ex ante basis. I think I encourage the PCAOB to structure the system so that we could measure. And one ideal situation is, for example, to introduce it separately for large firms first and small firms later, so that we have a beautiful discontinuity that allows us researchers to identify the impact of this for the results. So that is something that kills two birds with one stone, because number one, allows you to get a good estimates ex post, and number two, make it less costly for small firms to have this procedure. But I think it's fairly easy, because the question, the way I take it, is not that we need to measure precisely what are the benefits and what are the costs. We need to determine whether the costs are bigger than the benefits. And this can be done in a much more approximate way. So my simple calculation is, if we look at the cost of introduction of SOX, I look at the SEC numbers for cost of auditing before and after SOX, and if I got the number right, is an increase of 62%. Now, that's very, very large. I don't expect this regulation to have this cost, but imagine that this is the cost of regulation. So again, if I did that right, audit fees of publicly traded companies are roughly $6 billion. So a 65% increase in this will represent $3.72 billion. Let's be generous, let's say $4 billion, okay? So now what I say is, as long as this regulation can increase the probability of detecting fraud or reduce the cost of fraud, by an amount equal to the ratio between the 4 billion, which is the cost, and the amount of fraud, which is 800 billion. So by 0.5%, then this proposal is valuable. So if you tell me that audit firms are able to spend 4 billion and not reduce this probability by 0.5%, I think we should rethink audit overall, because we're wasting our money. So I think that by any reasonable number, even the number that Tom floated the American Chamber of Commerce, 36 billion, I can tell you with my calculation that as long as you can reduce the fraud by 4%, and I'm pretty sure that a good enforcement of non-compliance with the law regulation rule will be able to reduce by more than 4%. But as long as it reduces, this proposal is valuable. And by the way, and I will postpone to a second intervention, I have not factored in the fact that, as was pointed out this morning, the baseline is already very high. So here we are taking enormous costs without factoring in that most of what this regulation requires is already requested. And so the cost must be very minimal. And by the way, if you're interested, I can provide a perfect solution with no expected cost of regulation and all the benefits, but I leave the suspense for the end on how I can do that.
Thank you very much, Professor Zingales. I wonder whether Mr. Rees could speak from the perspective of investors on the same question of costs and benefits.
Thank you, Martin. It's a great opportunity to be here to share our views. I'm Brandon Rees, Deputy Director of Corporations and Capital Markets for the AFL-CIO. I also serve as a trustee of our pension plan. Altogether, union members have over $1 trillion in retirement savings through their pension plans and are significant investors in corporations. Workers are also stakeholders in companies and have an interest in ensuring that illegal acts are deterred and detected to prevent accounting fraud. As other speakers have highlighted, I want to make 3 points. One, that the value of the NOCLAR proposal is first to prevent fraud. As we all are aware, the track record for auditors for detecting fraudulent accounting could be improved, and I believe having a specific explicit duty to consider illegal acts by clients and to have the internal reporting mechanisms as proposed are entirely appropriate, and frankly, what investors already think their auditors are doing. I had the pleasure of attending the Wells Fargo shareholder meeting in 2017 after the cross-selling sales fraud came to light, and the investors were demanding, retail investors in the audience said, where was our auditor? Why were these illegal acts not detected? And the CEO, correctly under the accounting rules, replied, well, it wasn't their job. It wasn't their job to detect it, and therefore it went undetected. Secondly, it's my belief that by having a specific obligation to consider and report legal and regulatory violations will have a therapeutic effect of deterring bad acts. Locksmiths have a saying that doors have locks to keep honest people honest, and it's the idea that if auditors have a duty to consider potential illegal acts, that can help deter and keep people executives from feeling the temptation to bend the rules, so to speak. And so that is beneficial. And then thirdly is maintaining investor confidence in our capital markets. Since the Sarbanes-Oxley Act was passed in 2002, we've seen the S&P 500 increase fivefold. And a large part of that is trust and confidence in our accounting process. In 404, for example, and because investors believe that auditors are providing that insurance. And it's frankly hard for me as an investor to understand how an auditor can provide assurance that the financial statements are accurate if they're not doing a risk assessment for the potential for illegal acts to have occurred. And so, I just want to remind everyone what this proposal is doing. It's updating and replacing the AICPA standard that was adopted back in 1988. I was 14 at the time, so I had to go back and look up what happened in 1988 to refresh my memory. But that was, George Bush was running against Dukakis for the president. Gorbachev had just introduced perestroika in the Soviet Union. And George Michael's song Faith was the top of the Billboard chart. So it's been a long time since these rules have been updated, and they were only adopted by the PCAOB as a interim step for final rulemaking. It's my understanding that the AICPA has actually updated their own standard, and so there's actually a higher standard in place for private companies compared to public capital markets that we as investors, that working people have their retirement savings invested in. So I just want to reiterate our strong support for this proposed rule. And in terms of the benefits, just preventing just one corporate accounting scandal, one WorldCom. That was $175 billion in value that was destroyed with the collapse of WorldCom. And then there are the second order effects on the economy that are not even considered. That's everybody looking at the cost to investors. What about the 30,000 WorldCom employees who lost their jobs? What about the communities that company operated? Those are economic impacts that this rule, the NOCLAR rule, will help prevent that type of accounting fraud from hurting not just investors, but also employees and other stakeholders.
Thank you, Mr. Rees. That already goes to, question 4 that I was going to ask. But that's why I asked all the questions ahead of time, assuming that some of these responses might get bunched. So thank you very much for that perspective. I see Mr. McGowan have the hand up. The CAQ has also provided a cost estimate, and he's also here to speak about the ACC estimate. And again, I would very much appreciate if you could briefly outline what the methodology is by which these estimates were arrived at, as well as any justification for these methodological choices. Please take it away.
Sure. Thank you, and appreciate being here this afternoon to talk about this important issue, and just kind of reacting to picking up a little bit on what Mr. Rees said about the standard not having been updated since 1988. I can assure you from my work with our task force members that we certainly are supportive of modernizing this standard, and that was our position in our comment letter. I do think, though, that based on the conversations we've heard this morning, as well as comment letters that were submitted to the PCAOB, I think we all, we're not all on the same page in interpreting that this standard is just a minor update to bringing it up to what the AICPA or the AASB have updated their standards to be. So I do think that what's proposed, where we all are interpreting, some are interpreting, right, as more substantial. I think that's where, right, the importance of data and understanding the economic costs and benefits of the proposal is absolutely important to whatever the path forward is for this particular project. And I do think that from, picking up a little bit on what Mr. Quadman was saying earlier around the PCAOB's requirements, around what they need to do from an economic analysis standpoint, we certainly, in our comment letter, were of the view that further study and evaluation were certainly needed. I think that, in my view, the PCAOB has not sufficiently studied the costs, benefits, and alternatives in the proposal that was put forth last summer. I think that in our analysis of the comment letter submitted to the PCAOB, we certainly saw many commenters question the robustness of the economic analysis that was included in the proposal. I do think that you're right. We did try to quantify what we thought perhaps the costs of the proposal could be. But I think that in doing that, right, we, the CAQ, are a little bit more limited in what data is available to us. I think that the PCAOB likely has access to a bit more data than us. And I'd be curious to understand, what outreach could have been done with the accounting firms or audit committees or issuers to understand what some of those costs could be. Agree with some of what Colleen Professor Hunnesberg was saying earlier about what some of those costs could be, like the cost of implementing the rule. But so we did look to, for purposes of our comment letter, we looked at what the costs were of implementing SOX. And so looking at that, we thought that there was about a 59% increase in audit fees from 2003 to 2004 as a result of SOX. If you applied that 59% to audit fees in 2021, we came up with a potential $9.1 billion increase. But I think the difference we thought with this proposal compared to SOX is depending on how you interpret the proposed requirements and what those requirements would be, if they did require more of a legal expertise, that would even make probably the cost even more expensive and perhaps different than the cost to implement SOX. And we did find a study from Wolters Kluwer that had on average what companies were spending, large companies were paying their legal counsels, and kind of we use that percentage to try and estimate what we thought the potential increased cost could be from a legal expertise needed. And I think that we assuming that it wouldn't be exactly the same as what companies incur, which was about $148 billion. If it was even some subset of that, say half, you'd get to $74 billion. So again, I think we attempted to use publicly available data to come up with a number. I think holes I'm sure could be poked at that estimate, but certainly I think that we came to the consensus that the cost could be in the billions. Looking at the benefit side of the equation, that's just the cost. I mean, I think that to me, when I think about the proposal, and while it does make reference to large dollar losses in connection with a couple of events that occurred, to me, it doesn't provide evidence that company NOCLAR is widespread and prevalent. And I think to think that any one regulation could prevent one-off events like some of the large events that were mentioned in the proposal. I just think that perhaps this is a solution that's overcorrecting, perhaps. Now maybe there's some tweaking that can be done that modernize it, but doesn't fundamentally change the responsibility of the auditors. But I do think that those are real things that we need to think about. And I even think probably in addition to economic analysis, which I know is the point of this discussion, but I also think it's whatever the alternatives are, whatever the final requirements wind up being, I think demonstrating how those requirements will prevent some of the large events that were referenced in the proposal will perhaps help us understand what's being solved for here.
So thank you very much. I appreciate speaking to the methodology. You mentioned that there could be data at the PCAOB that you imagine we could be using to inform the costs. If you have any specific data in mind, we would welcome a pointer to that. Also, I wanted to follow up. You mentioned that in terms of the legal costs companies presently incur, if one takes, say, half of those, I wonder if there's any explanation of how you arrived at the halfway mark in order to address that. I'll ask the follow-on question I want to ask after that, just to give you more time in case you need to. I did want to ask Professor Honigsberg and Professor Zingales on taking SOX as a baseline. So I heard Professor Honigsberg say that she does not feel comfortable quantifying, and I heard much more optimism from Professor Zingales. So I wanted to hear what the disagreement there is. And on the question of the one-off event you just brought up, I will want to call on Professor Karpov, who has studied the prevalence of these items as well. And I see Mr. Croteau's hand up, and Ms. Posner has studied various of these events as well. So I want to go in that order. if I may, but first back to you, Mr. McGowan, in case you want to respond to these specific queries.
Sure. I mean, in terms of data the PCAOB has, I mean, I think a bit of this came up this morning with the baseline understanding of what auditors are doing today with respect to the requirements and what is the incremental effort being proposed and what costs do the accountants think they're going to incur with respect to those. But so that's what I was referring to is that the baseline of what's being done today and the cost of that. In terms of our assumption around that was really more of an, I mean, more just trying to get at, we're recognizing that the auditors wouldn't incur the same level of legal expense that companies do, recognizing, right, that they're employing lawyers for a whole lot of things beyond compliance with laws and regulations. And so that was simply meant to represent that it would be a subset of dollars spent related to certain laws and regulations. So there's no magic science behind that. Again, we were simply trying to quantify a dollar amount for purposes of our comment letter.
I appreciate that. Thank you very much. Let me contradict what I previously said and go backwards and start with Mr. Croteau, who might be able to inform the question as well.
Yeah, thanks very much. I've been listening to the dialogue here, and first of all, appreciate being invited back to this panel as well. And you have a very difficult task here. But when you think about the discussion on the last two panels and then what I hear now, the starting point for this has to be agreement on what it is you are trying to accomplish. And I worry that dialogue is incomplete at the moment. And even as I hear some of the discussion around fraud and WorldCom, for example, which was an accounting fraud, plenty has been done relative to the standards around fraud for accounting fraud. When you think about the risk assessment standards and the work of the PCAOB, SOX 404 and 302 certs, lots of things have been done. Certainly, I think it's an area where incremental attention and focus is warranted. We have, as a firm, our own initiatives, which we're calling our actions to enhance confidence in the profession. We're focusing incremental efforts around things like the whistleblower program, not that we don't today, but incremental efforts there, fraud risk assessment and the like, voluntarily beyond what's required in the standards. And you can read about that in our audit quality report. I mention that because I think those are good topics to spend time on, but I don't think that has anything to do with the proposal. And then when you talk about what's in the proposal, it's back to being upfront about what it is we think we're going to accomplish with the proposal, because I don't believe that the proposal or any proposal for auditors can stop entirely illegal acts from occurring. And so
Mr. Croteau, I apologize for interrupting. I promise I'll let you finish whatever else you wanted to say, but I do want to jump in here. I don't think the argument is necessarily that they would stop in the entirety of it, but Mr. Zingales previously calculated a small fraction thereof.
Yeah.
Can you speak to whether you think there's a chance there would be a small fraction that could be prevented?
Yeah,
I just wanted to clarify that. I will let you finish after that. Sorry.
Yeah, sure. And I'm not sure it's quantifiable per se, but I do think that there's an indirect benefit that could occur, like there is from a lot of things that auditors do, that could be somewhat preventative or help with earlier detection. But again, I think you've got to identify up front how much you're expecting auditors to do, back to the discussions this morning, relative to identifying matters beyond what management's already identified. And there are costs to that. In risk assessment, you think about risk assessment and procedures and how far one goes, there are costs to that, and decisions need to be made around that. And obviously informed by economic analysis. I think you've got a lot of data from a standard setting perspective, or from an inspections perspective, that should inform standard setting here, relative to, even in hindsight, relative to the work that auditors are performing today, and where it might be helpful to be additive. Also, the baseline discussions this morning were hugely important, because the baseline is not what's in the current standards today. Auditors are doing more because there are a lot of reasons auditors are doing more, but certainly at least the large firms are doing more because of what's in the ISAs and then incremental things that we've done over time because of other PCAOB standards that affect the work that we do on ASC 450 around loss contingencies, and I don't think that's been factored in. So the increment may not be so large for some of what's being asked for here, but I think referring back to the earlier discussions is hugely important. If done right, in my view, and kind of what I was at least describing this morning, I think it accomplishes what many investors want. Probably not some of what we're hearing right now, that probably is not accomplishable, but the unintended consequences around specialists or quality or independence or the amount of time, privilege, all those things. I think all those things are manageable. But those are all really risks depending on where you land relative to decision making here. So I think it's important to step back, get those things right, think about the potential benefits in a reasonable way relative to the incremental efforts that you're thinking about. I also just want to mention is the idea of writing this in a way that it would be phased in. If it's done right, it should be scalable. And I think you do need to think about small and large firms, different size audits. But if done right, what we're describing this morning can be done in a scalable way. If you have to phase it in, I think you've done something wrong in my view. And then I just want to add the point on this dialogue does show to me at least that audit standard setting is different than certain rulemaking. And I don't want to get into a whole discussion about whether you re-expose or not. You guys will figure that out. But it requires a less insular approach where these kind of debates around the words in the standard can happen and inform the process. And I think this demonstrates that what's happening here today. When you think about the proposal, the range of way people read the proposal. So whatever you do next with this and your cost benefit analysis, I would get some sunshine on it before it goes anywhere else, because it may not be read as you intended, and this demonstrates that.
Thank you very much for that, and also responding to the large versus small firm perspective. So I'll take that opportunity to once more contradict my plan and call on Ms. McNeese, who is presenting a relatively small firm, and in particular just ask as a starter whether she agrees with the idea that large firms already do more than the standards, and if that's also true for small firms, or whether that might give rise to a difference in the costs, relatively speaking, to large versus small firms, and any other aspect that would shed light on the small firm question, of course.
I would not be able to speak to knowledge of what larger firms are doing necessarily. So I don't know if other firms or large firms are doing more or less per se. And I don't know that I would characterize our current audit approach as doing more than what's in the standard, but I do agree with I think Brian made a couple of points of there are things outside of the NOCLAR standard, fraud standard, for instance, where a lot of the concepts that are being discussed today are really taking place under that standard. What we're doing really just in terms of auditing assertions related to completeness of liabilities, including contingent liabilities, and incorporating things into there. So I think some of the concepts that are being discussed as perceived as being missing from what auditors are currently doing are actually taking place perhaps in other with respect to other requirements from the audit standards. And I do think we've talked at length, throughout the day today in the different panels about, there may be some perception that there's ignoring of indirect effect laws and regulations, and I think that's just not true based on the current standards as well. So I think there may be some misunderstanding of, as Brian said, kind of the baseline of where we're starting from based on that. And I'd like to maybe just also concur with one other thing that Brian had that I think is a really important point. I've edited my notes since the panels this morning because I think the cost element of this really we need to further define the scope. So when I think of what do I think the cost is, I think it depends a lot on everything that was discussed, particularly in panel 1, panel 2, to some extent as well. And really then what does the final standard incorporate into the scope? Because I heard a wide range of understanding and understanding of the words that were written and the intention of what the expectation was. And so I think really to be able to quantify in any way the cost, I think we need better definition of what the scope is.
Very good. Thank you very much. So Brian, I'll just refer to you as Brian because of my inability to correctly pronounce the last name. I apologize for that. You referred to inspections data that we might be able to use. I wonder if you had any specific data in mind there.
Yeah, so I mean, I think that, well, first of all, I think this would be a great area that your target team could spend time on in even a more specific way than is already covered in inspections, and probably in fairly short order, to make sure that there's a thorough understanding across the profession of the procedures being performed today, and how, to the extent to which those go beyond existing standards. That will at least give you help with your baseline relative to existing performance. I also think there's work that could be done, and maybe some of this I can't presume what's been done by inspections already or not, other than what I know from my own firm. But I presume that there's a fair amount of data relative to inspection comment forms today, where there's obligations today relative to ASC 450 and our audit work, or, relative to loss contingencies. Are firms doing enough there? Are we doing enough relative to assessing accruals and disclosures that are being made today? Are those not being made timely, and the audit work around that not sufficient? The PCAOB has the benefit of hindsight when they're looking at that work from an inspections perspective, and so I think there's presumably a fair amount of information and data that will help with all kinds of things. First of all, it'll help with what are the various points in the process today that you want to make improvement, and being clear about that, so that, for lots of reasons, to inform the economics around this, to inform what we actually do going forward, and the public policy decisions that are being made. So, and again, without knowing all the things that are done in inspections, I know that this is an area that gets looked at as part of inspections today. So I presume there's all kinds of data that would be available that could be very informative, and sharing some of that in the rulemaking and the cost benefit analysis relative to what's working well, what can be improved, is, I think, hugely important.
Thank you very much. Now I'll catch up with my promise and want to call on Professor Zingales and Professor Honigsberg on their view on SOX as a baseline and the ability to quantify.
So Colleen, go first.
Well, so I'm actually so happy that I went after Brian and after Carol, because I feel like they really outlined exactly where I was going. When I was going through the comment letters, there were most common comparison was SOX, and that people were saying, well, let's take the cost of SOX as a sort of anchor point. And it wasn't clear to me why people were picking that, because I think what you would want to do is, exactly as sort of Carol and Brian were describing, is first, let's figure out what auditors are currently doing, whether, what sort of overlap do we have with, loss contingencies or with the Exchange Act requirements. And then let's better understand what is going to be incremental. And then let's understand the team that's going to staff those incremental tasks. What sort of specialists and are we going to need for that? How many hours are we going to need? And let's get a comparison of what this sort of additional work is going to look like and who's going to perform it relative to what we have now. And once we have that, we can better understand, all right, let's take an average, cost per individual and do at least some baseline calculations there. It wasn't clear to me from any of the comment letters that people were really taking that approach, and that they were really comparing what we're going to have in the future under NOCLAR versus what we have now. It was more like, hey, the last big thing we had in audit was SOX, so let's start with SOX. And let's, kind of sometimes use cost of SOX. Sometimes we'll say SOX doubled. Sometimes we'll say triple the cost of SOX. It just wasn't clear to me how they were getting those numbers. So in terms of like methodology, I think I would suggest really what Brian and Carol were doing, and let's understand what incremental is going to happen and who needs to staff that. And then that will give us a better sense of like, is SOX a comparison, or, how do we calculate the cost of this? The other thing too, that I would note is even if we're using SOX, it's unclear to me whether we should be using the cost of SOX when it was originally implemented, or if we should be using the cost of SOX now. And I think this actually really gets to Brian's point about sort of scalability and how we're implementing it. Because the cost of SOX, as I believe, I think Dennis mentioned earlier, if we just compare, what happened in 2003 to 2004 and the increase in audit fees, we're talking 59%. And thus you end up with a, estimate for additional audit fees of over 9 billion. But if you look at the cost of SOX over time, it's actually gone down. So for example, Professor Coates, who was on the earlier panel, actually has a paper on this, where he talks about, once people got more comfortable with SOX, you had more people who were able to perform the tasks. You saw a decrease in cost. So, for example, there was a survey published in 2013, which surveyed almost 3,000 companies, found that the total mean cost of compliance was 1.2 million, and the median was 0.45 million. The SEC's ICFR rule, the requirement where they rolled back SOX, ICFR for low revenue companies. Admittedly, they were talking about low revenue companies, so smaller companies here, but they suggested that it would save approximately 210,000 per year, comprised of approximately 110 per year reduction in audit fees. So, quite a big difference from that initial 59%. So I think we should think about, do we do SOX in implementation? Do we do SOX now? And especially to Brian's point about scalability, well, if you are able to delay it, you give time for implementation, then hopefully you can avoid that initial huge ramp up. So that was even if we do use SOX, I think, are we using the initial cost, or are we using once people get a little bit more established, because those numbers are going to be different.
Thank you very much for pointing to these studies. I want to just reiterate the request and invitation from the proposal and other places to please point us to specific data and studies that would help us with the quantification of these costs and benefits, and submit them to the comment file. This is, of course, for the panelists, but also for all listeners and viewers online. With that, let me get over to Professor Zingales, please, to speak to that.
So I completely agree with Colleen that it's much better to do a detailed study than doing a rough calculation. What I wanted to show is that do all the detailed study you want, but when the potential benefits are so large, they're second order. So if you have time to spend, go ahead, and I think it's going to be a fantastic job. But to me, as an academic, I try to invest the resources where there is some value added in investing, and it seems to me that the value added is limited. This said, I disagree slightly with your characterization of measuring the increment. If you go down that path of measuring the increment, you should not measure the increment between what they spend now and what they spend in the future. You have to measure what they should have spent now, because we know by evidence that they underperform the role of bringing up red flag of fraud as for 10A of the Secure and Exchange Act. And I can tell you actually two personal experiences when I was board of large companies that were trading on the NYSE, where the auditors completely failed their responsibility of bringing up to the audit committee some clearly red flags. So in one case was a $300 million payment for intermediation done to a company without a website. In a sense, this smells like bribery so far away, and they didn't bring up to the audit committee. This seems to me like a blatant violation of Section 10A. The other one was a tax fraud done at the expense of the Italian government, but using the company I was on the board of, which ended up paying hundreds of millions of dollars in fines, and was enough. This was done by a subsidiary that in 1 year was doing 1/3 of the sale to one company located in Austria. For those of you who are not European, Austria is a shady place from a fiscal point of view and business point of view. And if you do any analysis of the phone call, they had 1 billion euro in revenues of phone calls. Every phone call lasted either 53 seconds or 1 minute and 22 seconds. So any analysis say, wait a minute, the viability of the business of the subsidiary depends for a third on one company. If you're an auditor, do you want to check what company is doing and how reliable this is? This was not brought to the attention of the board. Even looking at evidence from the United States in recent years, look at the Colonial Bank case. The Colonial Bank case, the auditors were not doing that. And were not pointing out that a lot of the mortgages were fraudulent. And we're not talking, Brian, about accounting standard. We're talking about old-fashioned fraud, corruption, sort of fraud, tax fraud, and Wells Fargo. KPMG revealed that in 2013, they knew they were overdoing with incentive contests. They didn't say anything to the board at the SEC. So I think personally that we would not be here with NOCLAR if the audit firms had done their job under Section 10A. The only reason why we're here is because they don't do it. Now using the benchmark that they don't do anything and say, oh, it's very costly to do something, it seems like completely preposterous. Thank you.
Thank you very much for that passionate perspective. I see two hands up, but we haven't heard at all from Ms. Posner and Professor Karpov. So if I may combine questions two as a prompt to them.
Excuse me, Martin. Excuse me, Martin.
No. So
I've had my hand up for a while, and you've got back to several people a few times. Do you mind if I?
Yeah, I would like to hear from Ms. Posner and Professor Karpov first, and then we'll get back to you. So I would like to ask.
I just assume then that you're not as interested in the public company perspective.
No, I'm interested in questions, in answers to the questions we're posing.
Well, I was hoping to answer a few, which is why I've had my hand up for over a half hour.
Thank you. So I want to reiterate the second question, which is on additional studies or data to clarify the economic impact, and the submission of Professor Karpov points to that. And I'd also like to call on Ms. Posner on that. The fourth question points to the broader macro socioeconomic environment in addition to capital formation, firms' cost of capital, and so forth, if there was more trust in financial markets. So Professor Karpov, let's have you go first, given that in your submission you're referencing several studies and data on that topic.
Great, thanks, Martin. Well, just as things start to heat up, so my comments are going to be, if I can use first names, overlapping and similar to Colleen's and Luigi's, although my conclusions are very much closer to Colleen's and very different from Luigi's, in that I think we don't have reliable numbers on which to assess the benefits of the proposal. So Martin, I think, tasked me originally with trying to think through a framework with which to think about the cost and benefits from a social or society point of view. And that's what the comment that I submitted does, and which I'll follow. And I think in doing this, I want to point out that the terms fraud, misconduct, noncompliance get used somewhat interchangeably, both here and in the literature. And the empirical literature treats these various types of unsavory activities differently and draws from different types of them. So, for example, this will be important because if we're looking at empirical estimates of, say, financial misrepresentation related cost, that could be very different from the potential benefits of reducing non-compliance associated, say, with workplace safety activities. So the data that are available have to be interpreted with that in mind. So in thinking about this, I think there are four buckets of or types of cost that we want to consider. And the first is the direct compliance and cost of the regulatory bureaucracy. And this is the bucket that I think a lot of the discussion so far has focused on, trying to estimate how much the extra audit fees are going to be and how that redounds to investors. The idea is to risk increasing that cost associated with fraud and fraud management in exchange for a benefit of reducing the social cost of fraud in three other buckets. And the first of these three other buckets is for detected fraud. And here, my estimate of the cost of detected fraud is somewhat similar to the numbers that Luigi cites in the paper that he mentioned. And what are those costs? Well, they're the incremental cost of investigations in the legal process, including lawsuits. There's a loss in reputational capital, and in a project I was involved with, we estimate these costs to be quite significant. up to a quarter of market cap of the fraudulent companies. And what does that mean? Decrease in reputational capital means a decrease in the value of the assets the firm has that help bond the firm's contractual performance with counterparties. And it shows up with things like higher cost of capital. So paper by Graham and Liu in the JFE in 2008 show this. Papers by Chava, Murphy and al. In JFQA, JFE show that you have these specific types of costs that we lump together and measure in total as being about 25% of market cap. There are also firm level disruptions for detected frauds. Paper by Fish and Shiv Dazani show that there's director overturn, or turnover, I should say. Paper I've been involved in shows that 93% of named respondents at firms that are targeted for enforcement action by the SEC for 13B violations, that is misrepresentation, 93% of these people do leave the firm, which is a measure of the type of internal disruption. Then you have cost of undetected fraud. And here's where my thoughts on this differ significantly from Luigi's. What are the costs of undetected fraud? What would the cost be, say, if we had a firm that was misreporting its earnings for 2 years, it was never detected, and then goes back to truthful reporting? Well, some people might argue no harm, no foul. On the other hand, I think we do know that there are substantial costs. First, there are the cost of the resources burned up simply to maintain and cover up the fraud. More importantly, during the period in which the books are in error, you're going to have price distortions, and the price distortions are going to lead to suboptimal investment to the extent that managers of the target firm and other firms use price signals to help guide investment decisions, and they'll have suboptimal portfolio formation as investors bear risk suboptimally because they're dealing with distorted prices. Now, my estimate of the size of the price distortions come from an exercise in which we use various types of machine learning models to try to understand about how much undetected fraud is going on at any given time. And here we're talking about financial misrepresentation. And without getting into the weeds, the exact estimates depend on things like how you tune the model. That means how you weight the cost of type 1 and type 2 errors in classifying firms as fraud or not firms. And they depend on things like how long you assume violations are going on. But in a base case estimate, it looks like at any given time, on average, you have a large number of firms, up to 24%, that are engaged in accrual management that distorts prices, and the price distortion averages about 10%. That is, these firms' prices are inflated by 10% compared to a benchmark in which this hypothetical benchmark where you have full information. But the damage doesn't stop there. Investors, knowing that there's some fuzziness in the information that they're getting, are going to apply a discount to all firms. So even non-fudging firms are going to have a price effect, and we estimate the average effect to be about a 3.3% decrease or distortion in the prices of the shares of firms that are not fudging or pushing the books.
So that's like an asymmetric information discount. Is that the right way of thinking about that?
That is, yes, that on average, investors are not on average going to overpay or for shares, so they're going to discount all shares accordingly.
So can I ask you, in the interest of time, to also speak to any societal trade-offs, so not just on investors, but perhaps the environment, social capital, and so forth?
Yeah.
What does the literature say there?
If I can, I should point out why I disagree with Luigi's estimate on the effects of the undetected fraud. And Luigi knows this. I wrote an extensive note once about this. I think in the estimate that he on which he's relying, it draws from another paper that shows that in the firms that the author of that paper think are misrepresenting firms, they experience a decrease in share price performance of 11% compared to other firms. And if you apply that 11% number as a measure of cost of fraud, you get the numbers that Luigi was presenting. And I just think that is not at all related to the cost of fraud at undetected firms. I think it gets cause and effect backwards. So that's a hopefully good faith, honest disagreement with that particular measure and why my angle on this is different. You mentioned societal spillovers. Here, I think there's a lot of really important work that we're so far not giving much attention to, and that is to the extent that you can decrease the incidence of fraud. There's a lot of work showing that a decrease in fraud or the perception of fraud increases trust in social capital. And here, I just criticized Luigi. Let me praise the leading work that he and his co-authors have done in a number of papers that help show, along with others, that higher trust and social capital are associated with higher use of credit, financial market development, industrialization, trade, and economic growth. Increase in fraud or the perception of fraud decreases stock market participation. Quentin DuPont has a paper that shows that the effect is to decrease households' investment in the stock market, and ex post measures of the impact on their wealth is in low six figures measured over time. So, so again, I think we have some way to start to get some traction on these measures. If I can point to one last thing, I left out an important area that when we've been talking about the direct cost of the regulatory process and compliance, there's one more aspect of that I think should be considered, and that is the cost of regulatory burden overall. And here I want to refer to a couple papers by Joseph Kalmenovitz and co-authors, where they have this interesting data-intensive measure of regulatory burden that I think is persuasive, and in which they're able to show that regulatory burden is associated with higher cost of goods sold, more overhead spending, less investment, more lobbying expenditures, and even the being in the pipeline, having regulations in the pipeline, such as this one, is associated with higher political uncertainty and lower investment. So again, big cost of doing this type of proposal, but also big cost of fraud that hopefully you might be able to make some traction on.
Thank you very much for that perspective and all the references to studies and data. Now let's go in the planned order of Ms. Posner, then Mr. Quadman, and then I do see the other hands up as well.
Thanks, Martin. So I'm not an economist, so I'm not an accountant. I occasionally kind of play one on TV in the course of litigation that I bring on behalf of institutional investors against companies that commit fraud. So I'm pretty well versed in the kind of fraud we see both by corporations, but also occasionally by accounting firms. And I thought I'd start by addressing a couple of the comments I heard with regard to the cost of litigation, then turn to the benefits. With regard to the cost, I thought what Brian said was, and then Colleen reiterated this perhaps or expanded on it, I think understanding the incremental difference between what the rules already require auditors to do and what this rule change would require them to do is a really important quantification. Quite frankly, I have a hard time understanding how what this rule requires of accountants is all that different than what is already required via other aspects of the rules in terms of risk assessment and otherwise. So I do think understanding that delta is a really important one, so that you understand whether the costs kind of outweigh those benefits. When you have a handle on what that is, I think addressing some of these comments about what the costs flowing from that change would be are kind of easily dispensed with or at least negated in some material respects. So, for example, one of the things I heard was, oh, there'd have to be significant additional consultation with subject matter experts. That's something that the accounting rules already require, particularly with regard to the areas that are the material subject of the financial report. So I would hope that in most instances, the accounting experts are consulting with those subject matter experts on a regular ongoing basis in order to fulfill their obligations under PCAOB standards to begin with. Same thing with regard to communicating with legal experts. I just read an article a week or two ago talking about the fact that the big four accounting firms receive billions of dollars in revenue every year from the legal services that they provide to their clients. They are the largest law firms in the world. So the idea that somehow there is not this internal legal expertise is kind of baffling to me, and certainly exists for them to consult with to the extent it's necessary. We heard a little bit about the fact that somehow these rules lead to less IPOs and less public companies, and that the costs of rising capital will be impacted by the change in these rules. I don't see any connection to the specific rule change being offered here. And more importantly, it's the same charts and the same arguments I see in response to every single rule change proposed by the SEC or the PCAOB, no matter the subject matter or topic. I've heard the same testimony. I've seen the same charts at least, I don't know, 100 times over the past 5 or 6 years. It's the same arguments that are raised in the Fifth Circuit when the chamber challenges every single rule change the SEC and PCAOB make. It'd be nice if we saw some kind of specific direct connection to the actual change that is being proffered here and how that might be affected by it. Talking now just with regard to the benefits. Just to give kind of a slice of what we're talking about here, between 2018 and 2023, so just a 6-year period, we saw 608 securities fraud class actions that were settled for approximately $27.5 billion, so a little less than $5 billion a year. Now, the amount of the settlement obviously does not necessarily reflect the total cost to investors as a result of that fraud. On average, and by the way, I'm getting all of these numbers from the Cornerstone Group. Cornerstone Group uses professors who defend corporations and securities fraud. So this is not a liberal think tank by any stretch. These are the folks who defend corporations for a living. They assess that this number is a very small fraction of actual simplified tiered damages in securities cases. They average, they say that the number ranges from less than 20% of damages in the smallest of settlements, so under $25 million, to about 2.5% of the largest largest settlements, so $1 billion plus settlements. I can tell you last year, since it's come up a couple times, I settled the Wells Fargo case. We settled that case for $1 billion. We actually received 25% of our estimated damages in that case on behalf of investors. There is no comparison to that. That is like off the chart, not even close to what is ever recovered in securities cases, particularly securities cases of that size. And that was just a quarter of the estimated damages in that case. So while $27.5 billion is a lot of money already, just over a six-year period, the number of actual damages and loss suffered by investors as a result of securities fraud is infinitely higher than that number. That also assumes, of course, that every valid securities case survives a motion to dismiss. For those who are litigators on this case, on this call or listening in, know that surviving a motion to dismiss in a securities fraud case is extremely hard. Approximately 50% of cases survive a motion to dismiss. That doesn't necessarily mean that the other 50% were not sufficient or did not mean that there wasn't actual fraud. It just means that they weren't able to meet the extremely high standard in securities fraud litigation. So it's undercounting the number of cases in that regard as well. It also assumes that every instance of fraud is detected and that a lawsuit is brought in the first instance. But I don't think we even need to quantify that undetected fraud, as we kind of heard this debate going on, to know that just based on the detected fraud, the extreme impact on investors from fraud that is detected. Often, by the way, not detected by auditors, it's detected because it comes out through other mechanisms of action, unfortunately. So I think that's a really important kind of numerical way to measure the benefits here of what a very small percentage of detecting fraud could mean for investors. Just a small percentage change would have a huge impact on investors. The other thing I thought I would talk about is something a little bit more amorphous that I can't necessarily put numbers on, but perhaps Brandon could speak to this a little bit as well, which is that the reason institutional investors invest in the US markets is because they believe the US markets are generally as free from fraud as they can be, that they are better than other markets around the world, that because we have the SEC, because we have private enforcement, that there are opportunities here to ensure that their investments are safe. And if they do not have that comfort, if they do not believe that they are getting the benefit of paying the additional cost to invest in US markets, and that the folks who are supposed to be the gatekeepers for our markets are not doing their job, they will not invest in US markets, or at least not to the same degree as they currently do. And at a time at which the markets across the world are considerably more available to institutional investors in particular, and that they are widely deciding to invest abroad and not just in the US, the idea that we wouldn't want to have those added protections here seems to me to be something that corporations in the chamber would be concerned about, that you would want to have the added protection that these types of provisions allow, so that you have investors who want to invest in your companies as opposed to going elsewhere.
Thank you very much for that perspective. Mr. Quatman, please.
Yes, and that's why we did not support any legislative changes to SOX 404B, so that businesses had the certainty to grow from small to large. So to go into cost for a second, with our estimates, as I said before, we used audit analytics data. And the reason why SOX was used, and other commenters have used SOX as a baseline, is because between 2002 and 2003, audit fees doubled. So if you take a look at what we did is in using the data from 2021, updating that for inflation and just doubling that number, that's how you get to $36.4 billion. It does not include increased litigation risk. It does not include things like increased broker-dealer fees. So actually, in our view, that just based on history, that's even an underestimate. Additionally, when you take a look at the SEC's cost-benefit analysis in SOX 404, they were off before reforms by 4.67, a factor of 4.67, and even after reforms, they were off by 3.67. So SOX in and of itself is instructive as to what that can mean here. Additionally, as we had in our comment letter, the NOCLAR proposal has the potential to continue the concentration in audit firms that has been occurring, as I said, over the last 6 years. I would also have to note, I know there's been a discussion about societal spillovers. I have to note, earlier this morning, the SEC refused to include any sort of a double materiality consideration with climate disclosure rule. It is not within the ambit of the SEC or any organization that falls under it to take societal issues into account. And I would just raise as well, if anybody meets with companies that could go through the IPO process, look no further than the Jobs Act and the creation of the emerging growth company category, which Congress had to act in order to deal with some of the issues there, because companies felt that they could not be able to scale some of the requirements around that. And the two issues that are often raised why companies will not go public is proxy advisory firms and some of the PCAOB standards that are just not relevant to that model. And as Brian knows from his previous experience, it took over 15 years to get those SOX 404B issues factored out. And I would also have to say too, just with our cost estimate, again, yes, there are a lot of different resources within audit firms. There are a lot of different resources within companies, but this is going to require additional lawyers and additional subject matter experts in different areas that are non-legal in order to deal with some of the issues that are going to be raised here.
Okay, thank you very much for the perspective. Now, just to tally things up, we have a bit less than half an hour to go. We have 2 questions to go and lots of hands. I do think I kept track of the order of the hands. I just wanted to remind us of the question. So one is to the extent there are alternatives on the table, whether there are studies or data that could help us estimate the benefits and costs of those. I haven't heard any so far. We can skip the question if there are no responses to that. But then also the overall question of, in the light of the discussion that we heard so far, whether there are any updates to the views. Again, if that's already implicitly covered, I'm happy to essentially skip these questions. But with that, I'll go in order. Professor Zingales, I think, was first and might want to respond to the comments that Professor Karpov made, or anything else, of course. Please take it away.
Yeah, no, I appreciate Jonathan's comments, and I think that I want to make it clear where the disagreement is, in the sense that half of the cost that I described comes straight from the probability of having fraud and the cost of fraud that both of us agree on. So even if we were to put at zero the cost of undetected fraud, which I don't think is zero, because honestly, if this was zero, we should abolish auditing. And it's just, in this way, we are sure that nobody's caught. Actually, not only abolish auditing, abolish the SEC, the PCAOB altogether, so nobody's caught and everybody lives happily ever after. So, but even if we take that extreme view, which of course I'm not taking, we still are at 400 billion a year, which is a very, very large number. And so all our argument goes through, even under this extreme assumption. And I want to be very clear, because I think that there is often a confusion, and Jordan, I think, play on that confusion. We're not just talking about financial misrepresentation. We're talking about fraud. And the example I brought of Colonial, Wells Fargo, and the 2 other companies I was describing is exactly of that type of fraud. So I think that that's pervasive, that's very costly, and I think that the benefits of reducing it is very large and can be obtained with very little. In the cases that I described, if the auditor had done their job normally, would have been avoided and saving all the legal cost. I think that all the legal costs that Dennis estimates, I think that if that's a wrong estimate, because those legal costs will not occur, because those are to patch the problem. If you fix the problem to begin with, you don't have those costs. So in fact, we have to say that introducing this will save corporation all the costs that he estimates. So instead of being a cost of this regulation, that should be a benefit of that regulation.
Thank you, Professor Zingales, and we'll hear from Mr. Temple shortly as well. I first wanted to make sure, Mr. Quadman, your hand is still up, whether you got to say everything you wanted or whether there was an...
No, I just wanted, that actually goes to one of the 2 questions you were thinking of skipping. Some of the academic studies that are in the file, in the common file in support of NOCLAR, actually also look at not-for-profits as well as non-public companies, and it's really inappropriate to use that as a data set to justify an audit standard for public companies.
Thank you for that. The next on my list was Mr. McGowan. I hope I got the order right.
Thank you. Yes. So just picking up a little bit on something that Ms. Posner mentioned about institutional investors, that we did do a survey of institutional investors. So the CAQ from time to time do interviews and surveys with institutional investors. And given that the primary thrust and underpinning for the PCAOB's proposal is investor protection, in January we asked institutional investors about the NOCLAR proposal. And some of the things we found was that according to this survey, most investors responded, about 88% responded that the information available today on NOCLAR meets most or some of their needs. So I think our reaction to that was that, that might suggest that investors are not looking for the substantial changes to the requirements that the PCAOB has proposed. And perhaps, as Ms. Positer was mentioning earlier, that the attractiveness of the markets and the gatekeepers maybe are working here. And so it doesn't, again, maybe there needs to be some modernization, some updating, but not substantial changes. When we asked them about, who these investors believe were most responsible for better detecting non-compliance and fraud, only 17% of investors responded that public company auditors could do a better job. And nearly 7 in 10 of the investors believe that the costs associated with the PCAOB NOCLAR proposal reporting requirements are too high to justify the updated rules. While our survey showed that investors would support some increase in cost to bolster auditor responsibilities on company NOCLAR, the majority said a 30% increase in costs or less. And so I think that, and I think we heard even this morning from the gentleman from the FedEx board, mentioning that he's not getting he meets with hundreds of investors a year and is not getting questions about NOCLAR. So, I do think that there's probably an opportunity here for the PCAOB to engage with investors more broadly. And perhaps, there were some investors that did submit letters into the comment file. And I think hearing from them as to, those that I know we heard this morning from some that were supportive, but I think it's equally important to hear from those investors that were not supportive of the proposal. And I think that brings me to kind of one of my final points, which is just I think that multi-stakeholder dialogue is really needed to drive to a consensus on a standard that's practicable. I think, given the differing views and interpretations we heard in the panels this morning, and even the discussion this afternoon, I think just underscores kind of the need for really transparent and robust dialogue. Based on our analysis of the comment letters submitted to the PCAOB, 19 commenters, or 14%, said the proposal should be rescinded or withdrawn. 22 suggested that the PCAOB hold further dialogue. So very pleased that this roundtable is happening today. But I do think that this, it's going to take more than one virtual roundtable, I think, to really debate these issues and really come up with a path forward that is practicable and is solving for the problem that we need to solve for, and that an auditing standard and the auditor's behavior is the right mechanism for solving that problem. Because if the request is for more information about company NOCLAR, an auditing standard may not be that solution.
Thank you, Mr. McGowan. Mr. Croteau, I did my best.
Thank you. Back to the earlier comment I made that you have a difficult problem here to solve relative to your economic analysis. The discussion we're having now again demonstrates, I think, that there's a range of things that people are focused on here. And I do think that we have to be clear if there are aspects of the auditor's responsibilities on fraud that we want to focus on, we certainly should. There's been a lot done in that space today. More could be done. I think, Luigi, to one of the first conversations you and I had together where you were trying to convince me auditors weren't responsible for fraud today, and certainly we are at a reasonable assurance level relative to financial reporting and misappropriation of assets. And I think that's important. A lot's been done in that space. More could be done. In fact, the CAG subcommittee, which I sit on emerging issues, and I'm speaking only for myself in this regard, but we're working on some recommendations in that regard, and there's been dialogue from a CAG perspective. And I mentioned our actions to enhance confidence as a firm. But a lot of this discussion is not well linked or sufficiently linked even to the wide range of things we were discussing this morning. And so you think about the range in which people are reading the existing proposal, and some of this is outside of that, although some of it's already addressed, I think, in existing standards. But this, I think, just demonstrates the real need to have clarity on what it is that we're trying to accomplish. And it doesn't, I don't, when I say that, I really don't mean that there's not things we shouldn't do. I really do think there are, but I don't think there's clarity in some of these discussions that can sufficiently inform actions for the board or the staff, I should say. And I did just want to comment, just to be sure, in the US, accounting firms, it would be illegal for us to, speaking of illegal acts, illegal for us to practice law. So accounting firms in the US are not practicing law or making revenues from doing that. That would be illegal. The other thing I just wanted to mention was a few of the examples that have been given demonstrate that either 10 Cap A had not been followed, or there are circumstances where perhaps enforcement was warranted relative to some particular set of facts and circumstances. And I think those are informative examples, perhaps relative to, is there something to do in response to that? You look at the nature of it, the frequency of it, what generally a performance is. There's a lot of factors one would consider, but just because we can find an example of something, I don't think means necessarily that that's justification necessarily by itself. It could be, but it may not necessarily be. So again, I think that's where the inspections process, in addition to inspections, enforcement, and all the information that the board has relative to thinking again carefully about what problems do we think we're solving, what do we think the attendant benefits would be, because this is a very, very broad discussion. And then I'll just close by saying the proposal, let me, two data points. One is the IAG letter, which says, we believe such costs to investors are significantly more than the cost derived from ensuring companies are not engaged in illegal acts, including fraud, ensuring that. And then, you know, when you look at the PCAOB's proposal, there's the reference to harm over 20 times. Only 4 of those that I could find referenced risk of material misstatement. So now we're talking about prevention of I think, the illegal act to begin with. So, and some of this, I think, goes broadly to all kinds of fraud, which is, again, kind of handled separately. So again, don't take any of this to mean I don't suggest there's good things that can be done, and I'm supportive of advancing the current standards. But I do think that this is a pretty wide range discussion that we're having that you know, you've got a lot to think about here.
Thank you very much. The order that I have on my sheet here, based on when the hands went up, is Professor Honigsberg, Mr. Temple, Ms. McNeese, Professor Karpov, and Mr. Rees. So Professor Honigsberg first, please.
Thanks. I'll be quick. I know we have a lot to get through. So I just had 2 points to add. First, in addition to when Professor Karpov had an excellent summary of like the consequences of fraud, one other paper I would mention is the effects of fraud on employees, to the degree that you are considering these sort of effects more broadly as opposed to just on investors. But so after fraud, employees had on average about 9% lower wages and were 18% higher to have a separation from the firm. So if you then just kind of conceptually can think about it, you have about 17,000 people who lose their job in 1 month after WorldCom. Many of them are located in the same region. They all have to find a new job at once. And the jobs they find are often, you know, something they have to find quickly that is going to pay lower than what they had previously. And one thing to note about the study is that they found the effects were really concentrated on lower income workers because they just had less savings and so were less able to wait to find a new position. Whereas higher income workers were able to hold out for several months until they could find something else. The other point I would make is, so I'm not sure we're actually going to get to the question on sort of small and medium issuers. One thing to note, and I think this actually goes to just what Brian was talking about, is like, what are we really trying to achieve? Because the latest data that I see from Audit Analytics on restatements from 2021, so of the restatements, 73% were US filers who were non-accelerated filers. And then an additional 10% were non-accelerated foreign filers. So I think we can sort of say that the non-accelerated filers are where we'd be most concerned. And if we're thinking about the cost benefit analysis, well, the way the conversation was going earlier, it seemed like there was some inclination that maybe we want to have a loop, have a carve out for smaller firms. Maybe that makes sense. Don't mean to say it doesn't make sense. But then I would note those are also the firms that are most likely to have restatements. So, it's a little bit concerning. And this actually, to what Laura was saying too, is like, if we really want institutional investors to be comfortable investing in all firms, well, those are the ones who perhaps need the protection the most. And the additional, sort of comfort that NOCLAR might provide. I would also finalize by, Luigi, I am an Austrian citizen and I did not appreciate your comments. So, thanks.
Thank you very much. Mr. Temple.
Just with deference to the security litigation plaintiffs bar, the settlement of claims in securities litigation is not a measure of fraud, despite the threshold to bring such litigation, the Private Securities Litigation Reform Act of 1995. It is a business decision to settle such claims in cases where no fraud has been substantiated. But speaking as a smaller issue, the client's function within my company is robust. The proposal in many regards is duplicative of that function, which is not adequately acknowledged in the NOCLAR. Moreover, the 302 certification process ensures that self-identified compliance issues are disclosed by management to our CEO and CFO before they certify financials and are reported to our auditors. The PCAOB standards without NOCLAR are already sufficiently broad to cover what is needed. Thank you for the opportunity to participate on this panel. I look forward to PCAOB reevaluating the needs, scope, and precise nature of the NOCLAR and supporting that with a well-founded cost-benefit ratio. I need to duck off. I need to hop on a board call, but thank you very much, Martin.
Thank you very much for coming on the panel and the perspective. I saw Ms. Posner's hand go up. I did put you in the queue. So if you can hold on, we'll go in the order. Ms. McNeese was next in line.
Thank you. And I wanted to hit on some of the points from question 3 as it relates to small, medium-sized firms in particular. So I think it's probably quite obvious as it relates to the cost component of the equation here, that to the extent a firm that has a smaller public company audit practice incurs overhead cost related to this proposal, certainly basic math would tell you that cost is spreading over a fewer number of clients, and they would be disproportionately impacted there as opposed to larger firms. There would be overhead costs associated with implementing the standard, but I also want to point out, in addition to that, I agree with some of the points in Ms. Honigsberg's presentation that she shared on some of the unintended consequences. Small, medium-sized firms are less likely to have internal expertise, would be more subject to seeking out external experts, subject to availability of those experts, perhaps limited, pool of experts that we could call upon. So I would encourage in the cost-benefit analysis and thinking about the impact of small, medium-sized firms that we're not simply assuming all firms that are serving public company clients have Big Four accounting firm level of resources available to them. I also want to highlight too that I think the other aspect of this, and this was commented on to some degree already by Mr. Temple, but our client base that we serve, having a smaller practice, tends to be smaller public companies, the non-accelerated filers that internally have less resources, less robust systems and controls, et cetera. I'm not necessarily advocating for scoping out or anything like that, but I think it's important to understand that as we talked about in some of the earlier panel discussions about really starting with looking at what management is doing, and if you imagine a Fortune 500 company that has this really elaborate compliance department that you could go to as an auditor and see all of the different programs that they have and use all of that information to identify risks of noncompliance with material effect. To the extent you don't have that sophisticated system, I think that puts more burden on the auditor. And again, that may be the right answer, but that will increase the cost necessarily for the audit fees. And I think that would be disproportionate disproportionately adding more cost to the audits of those smaller companies because of that.
Thank you very much.
Yeah, I just
apologize. I didn't mean to interrupt. Please continue.
Yeah, sorry. I think that covers for the most part. There's probably more, but I know we're tight on time. I just wanted to maybe address a couple other comments that have been made in the discussion that I wanted to highlight. I've heard some comments that either the proposed standard is really not that different for auditors, like we should be doing all these things anyway, we should be seeking out subject matter experts, that there's not much incremental impact. And I would question then if obviously that has all to do with the discussions from earlier on what truly is the scope of the requirements, and I think there's a lot of uncertainty with that. But if the intention is really not to substantially change what auditors' responsibility is for, I would question then why we would expect a significantly different outcome and a result, and that suddenly now we're preventing billions of dollars of losses due to non-compliance as a result, if we're saying, well, no, this is really all the same thing auditors should be doing anyway. So that seems like a dichotomy to me, and I can't quite reconcile sort of how those two things would fall in line.
Thank you very much. And I saw Professor Zingala's hand go up. I don't know if we have the time to get to it because we still have to get to various hands and close the meeting. But I would just want to reiterate that if there's any evidence, data or studies on such unintended effects that Ms. McNeese just re-emphasized, please do submit them and refer to them in the comment file. It's very important for us to hear on them. So I have Professor Karpov, Mr. Rees, Ms. Posner, and if we get to it, Professor Zingalis to close out on it.
Quick, I guess, three quick comments prompted by the discussion, just for things for the PCAOB to consider as you move forward on this. One is, if you look at the compilation of the types of costs and benefits that we want to think about that I submitted, and I think also you'll find the same thing on the list that Colleen submitted, you don't see a line item for legal settlements or regulatory fines. And the reason for this is that such settlements are transfers. And if you're trying to take the perspective of costs and benefits to society, you would want to consider the cost to the payer of this transfer and also the benefit to the receiver of the transfer. And so I encourage the board to only consider such settlement or regulatory fine amounts as measures of the cost of fraud, only if you could somewhat persuasively tie it to some real deadweight loss. Second, my comments sort of swing both ways in terms of whether they favor the proposal or not. Similar to the comment that Ms. McNeese was just making, I have a genuine question about the effect of tasking auditors to a higher standard and to look into more areas of a firm's operations. On the one hand, Luigi's examples point to, are great examples, which suggest that, maybe if auditors were so tasked, they would have stopped some of those frauds. The counter argument is that they didn't stop them with existing rules, and they were violations of existing rules. So would the failures happen anyway? Really, what is the delta of the impact on fraud detection? That's a genuine question. I don't know of any work in that area. And my third comment is sort of a large one. It's about whether this considering social spillovers are part of the purview of the PCAOB, and I think there's an important distinction. I think I think I probably agree with Mr. Quadrum about the SEC's rule and that it's been considering, but I don't think that undermines the mandate that the PCAOB has in considering rule changes to consider cost and benefits for the, for the broader community. It's different to mandate a firm's social outcomes than it is to simply consider the broad social impacts of the PCAOB's, with acting within the PCAOB's mandate and jurisdiction.
Thank you very much. And you all know from my accent that I'm German, and Germans get very nervous when one gets close to the final time and there's a risk we'd run out of time. So I just ask you to keep it as short as you can. But Mr. Rees and Ms. Posner, then Professor Zingales, and then we have to close it out.
Thank you, Martin. This has been perhaps one of the most frustrating conversations I've had to participate in as an investor. To be lectured by the representative of the auditor and prepared community about the what investors think about NOCLAR is just really unfortunate. From an investor perspective, the cost of compliance with the NOCLAR rule is money well spent. And you don't need to take my word for it. You can look at it in the comment file. There's letters from the SEC Investor Advisory Group, from CalSTRS, the Council of Institutional Investors, Consumer Federation of America, and the AFL-CIO, all strongly supporting this rule. This rule will also benefit capital formation. If you're going to talk about the costs of SOX compliance, you also have to look at the benefits of SOX compliance. And as I said in the beginning, the stock market has increased fivefold since SOX was adopted in 2002. The decline in public company listings, the number of public companies, is completely immaterial because the value of public companies today as a proportion of our capital markets is as high as ever. This rule is vital to ensuring investor confidence in our capital markets because investors already think this is what auditors are doing. Our capital markets are the deepest and most liquid in the world precisely because of that trust. And we need to have strong rules in place to ensure that we honor that trust that investors, including working people such as my grandfather. He grew up during the Great Depression before we had federal securities laws. He hid his money, his life savings, buried in his trailer. Because of the PCAOB, because of the SEC, because of SOX, we now have investor confidence where working Americans trust their retirement savings in the U.S. stock market. And my last point is whether it's appropriate for the PCAOB to consider impacts of financial wrongdoing and fraud on other stakeholders beyond investors. Of course they do, because the PCAOB has a duty to protect the interests of the end users of financial statements. And that's not just the institutional investor community. Creditors, business partners, employees use financial statements to assess the financial strength of the companies that they're doing business with. The spillover effects of this rule are tremendous. They're not limited to the investor community. But that being said, based on everything I've heard today, even if we're able to prevent just one WorldCom, just one mega fraud from happening in the future, then this would be money well spent. And so I strongly urge the PCAOB to move forward in adopting this long overdue rule, a rule which, by the way, as I said in my introductory remarks, has not been updated since 1988. When George Michael was
I apologize, Mr. Rees. I just have to move on. My German genes are trickling through. So I'm starting to regret having agreed to call on Ms. Posner and Professor Zingales, but let's get to them.
I'll be very quick. I wanted to make the point with regard to SOX that in addition to the costs, you can also look at the specific benefits, and there's been quite a bit of studies done demonstrating the number of restatements and how they have gone down considerably as a result of SOX. And also the size of restatements has gone down considerably as a result of SOX. Both are economic benefits to legislation, which I think was considerably broader in scope, quite frankly, than what this is asking to do, but I think is perhaps a good proxy if we're going to look at the costs of SOX. The second point I wanted to make was just in response to what some of the accounting folks were saying. It is, of course, true that whether there is a large difference between what the rules require now and what this requires with this change, there might not be a demonstrable difference. I think the problem is that the rules as required now are not being followed, despite the fact that that's what everyone was assuming, which is what is precipitating the need for the update in the rules. And then the last point, I just wanted to make the point that Professor Karpov was making about transfers. There's a lot of economic papers out there that are contrary to the view that he just expressed, that it is not simply a transfer of wealth from one set of investors to another. I think it is absolutely an appropriate proxy for the harm to investors to look at actual securities fraud cases, whether, you know, some companies don't want to believe that they are actually reflective of fraud or not, you know, I'll leave it to them to say, but I think we can all agree that at least some portion of them is reflective of actual fraud.
I never thought I would get to say this to Professor Ingales, but please keep it short with your final comment.
Absolutely. So building on what Laura said, I think that what Carol is missing is precisely the fact that if the rule today is not enforced, it doesn't work. So what this, I think that the PCAOB is forced to create new standards because the old ones don't work. So I have a very simple alternative. So why don't we keep the rule as they are? However, every time we find out, like we found out in the case of the Wells Fargo and in the case of Colonial, etc., that the auditor had some information and they didn't raise a flag, then we do two things. Number one, we revoke the license to operate for that particular engagement partner for life. Number two, we charge $1 billion of fine on the audit firm. Now, the beauty of this system is, according to you guys, the cost of this thing is zero, because you're saying that everybody already applies. So because in equilibrium, this will be applied, the cost of this enforcement mechanism is zero, and the benefits are going to be large. So if you really think that everybody follows the rule, you're going to sign up to my alternative proposal. Thank you.
Thank you very much. Now I see Chair Williams in the screen. I'm aware we didn't get to what everybody wanted to say. My last plea to please submit any additional comments in the file. We read those and value them very highly in how we update the rule and the proposal. Thank you very much for that. Let me just make sure the comment file is open until March 18th. And while we welcome all comments, the staff are particularly interested in substantive comments, of course, concerning the roundtable topics and any points raised during the roundtables, including follow-ups we didn't get to. I also want to say the video of today's roundtable will be archived and available on the PCAOB website. And with that, I would like to turn the floor back to Chair Williams to close us out. Thank you very much.
Thank you, Martin, Barb, Karthik, and all of your colleagues who made today's event possible, including Brian Goodnow and Awilda Santiago in the Office of Communications and Engagement for managing the WebEx. And thank you to all of our panelists for taking time to share your valuable insights with us. You've given us a lot to think about. I also want to thank the public that is watching today. And as Martin said, the public comment period is open until March 18th, and we look forward to hearing from you. Thanks very much.